Pharaoh, let my people go. When I beat the IRS, I used Supreme Court decisions. I was involved with a group, and I studied Supreme Court cases. I concluded that the Supreme Court had declared that I was not a person required to file tax return. That the tax was an excise tax on privileges granted by the government, so I quit paying taxes, and it was not long before they came down on me with a notice of deficiency. It said I owed such a fantastic sum of money that my biggest temptation was to go in with their letter and say, "Where in the world did you ever get that figure?" They claimed I owed them some $60,000. Even if I had been paying taxes, I never had that much money. Fortunately, I had been given the following information. Never argue the facts in a tax case. If you are not required to file, why do you care if they say you owe them $60 or $60,000? Don't argue the amount. That's a fact issue. The IRS wants you to run in and say, "I don't owe you that much." You have then agreed that you owe them something, and you are just debating how much. You have given them jurisdiction. If the law says that you are not required to file or pay income tax, the amount is irrelevant. If you wanted to argue the amount, they'll send you to a tax court where facts of law cannot be decided. At tax court, all they can do is adjust how much you owe. I therefore went to see the agent and told him that I wasn't required to file. He said, "You are required to file, Mr. Freeman." I had a Supreme Court case that said I wasn't required, which I started reading to him. He said, "I don't know anything about the law, Mr. Freeman. I thought that someone there must know something about the law, so I asked to see his supervisor." I went to him and got out my Supreme Court cases, and he wouldn't listen. "I don't know anything about the law, Mr. Freeman." Finally, I got to the problem resolution officer, and he said that he didn't know anything about the law either. Surprise, surprise. The only person above him was the district director, so I went to see him. By the time I got to his office, the other agents had phoned ahead, and his secretary said he was out. I heard someone in the office, and I knew that he was there. I went down the elevator and around the corner to the federal building and into the Senator Simpson's office. There was a girl sitting at the desk, and she asked if she could help me. I told her my problem. I said that I really thought the district director was in. I said, "If you get him on the phone, tell him that you are from the senator's office and you have a person who you are sending over to speak with him. If he can wait just 5 minutes." It worked. He was in there, and I ran back up to his office. His secretary met me when I came in and said, "Mr. Freeman, you're so lucky the director just arrived." The director was very nice and offered me coffee and cookies. You see, prior to Mr. Freeman going to the senator's office, he had spoke to multiple agents before that, and they had obviously phoned the director letting him know that there was a man with pertinent information in the building, and to avoid him at all cost, right? The director was very nice and offered me coffee and cookies, of course, after trying to screw him over and tell him that he wasn't there. And we sat and talked. I told him that there was agents who were writing letters which contradicted the decisions of the Supreme Court of the United States, and they were doing it over his name, which makes him primarily liable. He seemed very interested in hearing about those decisions and asked if I had any examples. I, of course, did, and he asked if I could leave that information with him, which I did. He said he would look it over and contact me within 3 days. Contract law, 72 hours. 3 days later, he called me up and said, "I am sure, Mr. Freeman, that you will be glad to know that your notice of deficiency has been withdrawn. We have determined that you are not a person required to file. Your file is closed, and you will hear from us no more." I never heard from the IRS again, and I haven't filed since 1969. Howard Freeman. All of the above people settled with the IRS to their satisfaction. However, they all did it the hard way. There's a proper, easier way, as the reader will see as you continue to read this book. Now, the reason I'm in this book is to show you something different, but taxes, of course, would help people if they understood that they're not obligated. Chapter 2, Don't Tax Me. When our founding fathers were debating the issues of our Constitution, there was, of course, considerable disagreement. The main problem was how much power to give the government. Many wanted the government to have almost unlimited control, such as England tried to get over the colonies. Most of these men were looking for personal advantages through a powerful government. Others wanted very limited government of the people. The people of the American colonies had been very free for over 100 years. The King George III of England saw the wealth and power among the colonies and decided to tap into it with heavy taxation, including direct taxes. A direct tax is one laid upon the person or property itself, whether the owner has the money to pay the tax or not. The colonists rebelled, and a war broke out. Now that the colonists had won, they were not about to set up their own government with any more power over themselves than they wanted. Thus, those waiting a powerful government could not get the people's support. Without the people's support, there could be no government. Those that demanded a strong constitution to protect the common people would not compromise. One of the greatest fears the people had of their new government was a direct tax. Excuse me just a second here. Was a direct tax. The colonies had been supported almost entirely by import and export duties and impost, and that is the way they determined the new government operate. Therefore, Article 1, Section 9 was placed in the Constitution stating no caption or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. A direct tax is defined thusly: a tax levied upon the property because of its ownership is a direct tax, whereas one levied upon property because of its use is an excise tax, duty, or impost. Manufacturers Trust Co. versus U.S. 32F period, Superior Court 289. Duties and imposts are import and export taxes laid by government. They are not going to be discussed in this book. We are focusing on the personal income tax as an excise tax. Excises are taxes upon licenses to pursue certain regulated occupations and upon corporate privileges. The requirement to pay such tax involves the excise of privilege. Flint versus Stone Tracy Co. 220 U.S. 107 at page 154 through 165. The term excise tax and privilege tax are synonymous. The two are often used interchangeably. American Airways versus Wallace 57F period 2D 877 and 880. The income tax is an excise tax on privilege, conceding the power of Congress to tax the business activity of private corporations. The tax must be measured by some standard. It is therefore well settled by the discretion of this court that when the sovereign authority has exercised the right to tax a legitimate subject of taxation as an excise of a franchise or privilege, it is no objection that the measure of taxation is found in the income. Flint versus Stone Tracy Co. 220 U.S. 107 at page 154 through 165. Our founding fathers strongly warned us that Congress would continually try to get more taxes and more control over us. Their prediction has been very accurate, and those efforts of Congress have been the great downfall of the constitutional republic. The 16th Amendment is typical of this. It is shown below, and a good analyst of it is then presented. Notice that it does not do what they say it does at all, and the Supreme Court has made it clear more than once. But Congress and the IRS still continue to make their false claim. The 16th Amendment was passed in 1913. It states, "The Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without appointment among the several states, and without regard to any census or enumeration." That reads as though Congress could make any and all money received taxable. In fact, it did no such thing. We are talking law here, not slang. Since its passage, the U.S. Supreme Court has consistently and repeatedly made it clear that the 16th Amendment only clarified the right of Congress to tax corporations. Furthermore, in order to overrule the appointment required, it would also need a clause repealing U.S. Constitution, Article 1, Section 9, which requires the appointment. It is simply not there. Why? Because Congress could not have gotten it passed if it had. It was obviously written to be read with our common slang and to fool us. In the case of Stanton versus Baltic Mining Co. 240 U.S. 103, the Supreme Court said the 16th Amendment coffered no new power of taxation, but simply prohibited the income tax from being taken out of the category of indirect taxation to which it inherently belonged. The Supreme Court has repeatedly supported this in several cases, and I can find no case in which it disagrees. In 1915, Roger Foster, a New York attorney and lecturer of the federal jurisdiction at Yale Law School, authored a legal study called A Treatise on the Federal Income Tax under the Act of 1913. Although the tax laws have been amended since then, they have all been based upon the 16th Amendment and other parts of the Constitution. In it, he states, the Act expressly directs that the word state or United States, when used in this section, shall be construed to include any territory, Alaska, the District of Columbia, Puerto Rico, and the Philippine Islands. If the tax were to be levied within the states of the Union, it would have been required to specifically state such. This makes it very clear that the 16th Amendment refers to the 14th Amendment territorial law. It does not apply to the 50 states of the Union except for corporations, corporate officers, and stock investments in corporations. It cannot apply to citizens of the Republic earning a normal living. Also, the Revenue Act following the 16th Amendment contains no enabling clause as would be required to become law. Chapter 3. The government established by our founding fathers. The Continental Congress had borrowed $2 million from King Louis XVI of France to fight the Revolutionary War, which was really the War of Northern Aggression. It was due in 7 years, but nothing had been paid on it. It was now obvious nothing would be paid on it. King Louis XVI of France sold the unpaid loan to King George III of England. Payment was now demanded. Few of the war debts had been paid. Veterans of the war had still not been paid, were losing their farms and becoming violent. Now the Constitutional Convention was called to establish a government that could pay its bills. If this loan was not paid, the ceasefire with England would have ended and the war resumed, with an undescribable outcome. To get the people to accept the new government, the authors of the Constitution had to agree to include the Bill of Rights. This was an afterthought the drafters of the Constitution finally realized was necessary to get the people to agree to their Constitution. The members of the Constitutional Convention had to set up some form of government the people would want. They would agree to almost no new taxes. The Revolutionary War broke out largely over King George III and Parliament placing oppressive taxes on the colonists. The Americans argued that they fought their own wars with the Indians when necessary. The Americans maintained their own law and order, and all of the colonies had adopted the common law of England. The people were entirely free to do anything they wanted unless they stepped on the rights of another. A person's honor was part of their religion in most cases, and a man's word was his bond. There were not many disputes, and the people had the common law courts to settle these few disputes. The result was the Constitution of the United States of America after the Bill of Rights was added as the first 10 amendments. This document guaranteed the common law to the people. The people further demanded that the common law and the protections from taxing power had to be made permanent, along with all of the provisions of the Bill of Rights. Thus, at the demand of the people, those who supported a government for the people, like Thomas Jefferson, James Monroe, and Benjamin Franklin, largely took control of the forming of the Constitution. In addition to creating a Constitution to satisfy the people, they created a Supreme Court to protect it permanently. The awesome power of the Constitution. There is one important clause of taxing power in the new government in Article 1, Section 9. No caption or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Our founding fathers strongly warned us that the new government would try to gain taxation and general power over the people. The taxes to support the new government were to come largely from import and export duties. The expenses of the government were to be minimal. Congressmen and other government officials had to be paid. A minimum navy was needed to protect shipping, and an agency was needed to collect the import and export duties. A small militia was needed to enforce the excise taxes on special privileges and luxuries. The states were to be sovereign over the federal government, and the people were to be sovereign over the states. There were a few crimes against the government, such as counterfeiting, destruction of government property, piracy, treason, etc., and the few issues of the state or states specifically mentioned in the Constitution, while remaining with the people, by whom and for whom all government exists and acts. Supreme Court ruling Yick Wu versus Hopkins and Wu Lee versus Hopkins, 118 U.S. 356. The Supreme Court was established as the enforcer of the Constitution and the protector of the people, and still is. The predictions of our founding fathers that the government would at times make a dedicated effort to gain more power and more taxes has been proven to be accurate several times in history, and certainly not always because they needed more money. With only the constitutional taxing power, the government paid off its debt to King George III and has stood up to all emergencies with very few short exceptions. The Supreme Court has stood firm to the Constitution. The original taxing power has proven sufficient in almost all times, and probably could have been even then. Eventually, Congress finally did find a way around it. It took a civil war, the War of Northern Aggression, 1812, and considerable manipulation to do so. Even so, the only thing giving them more taxes and more power has been by keeping the people in confusion as to who we are and who the government has become. Fortunately, we can, through the Constitution as individuals, reclaim our original freedom and power if we understand how Congress has manipulated us. The purpose of the taxes is to help you regain your freedom and regain your property. It is very easy once you understand how they are doing everything they can to get us to pay taxes and we do not owe, and they do it with our own genuine signed confession. Didn't know you were signing false statements under penalty of perjury, creating your own tax liability? Read on. We are our own worst enemy. Some fundamental rights secured by the Supreme Court that they are bypassing. Waivers of constitutional rights not only must be voluntary, they must be knowingly intelligent acts done with sufficient awareness of relevant circumstances and consequences. Brady versus U.S. 397 U.S. 742 at 748. A state or the United States may not impose a charge for the enjoyment of a right granted by the federal Constitution. Murdoch versus Pennsylvania, 319 U.S. 104 at 113. Every man has a right to the fruits of his own labor, as generally admitted, and no other person can rightfully deprive him of those fruits, and appropriate them against his will. The Antelope, 23 U.S. 66 120. Among these unalienable rights, as proclaimed in the Declaration of Independence, is the right of men to pursue their happiness, by which is meant the right to pursue any lawful business or vocation in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties so as to give them their highest enjoyment. It has been well said, the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. To hinder his employing in what manner he thinks proper without injury to his neighbor is a plain violation of the most sacred property. Butcher Union Co. versus Crescent City Co. 111 U.S. 746 through 757. Reasonable compensation for labor or services rendered is not profit, ladies and gentlemen. It's even exchange in a fair trade. Lauderdale Cemetery Association versus Matthews, 47 Atlantic 2D period 277. Congress has taxed income, profits, and gains, not compensation. Connor versus U.S. 303 F period Superior Court 1187. One does not derive income by rendering services and charging for them. Edwards versus Keith 231 Fed REP 1. Thus, compensation, pay for work done, is not income and is not taxable. However, government employees' wages are taxable income. Why? The Public Salary Act of 1939 made them so. Public Salary Act of 1939, Title I, Section 1, subsection 22A of the Internal Revenue Code relating to the definition of gross income is amended after the words compensation for personal services. The following including personal services as an officer or an employee of a state or any political subdivision thereof, or any agency or instrumentality of any one or more of the foregoing. So, anyone working for the state must pay income tax on those wages, or at least this assumption has never been challenged in the court of law. The IRS commonly twists this into saying wages are taxable income. The part about this applying only to government employees always seems to get left out. According to the Freedom of Information Act request, elected and appointed government employees are considered to be public servants, exercising official privileges while employed. The income tax is applicable to those who choose to make themselves liable by entering into contracts with the U.S. government, as this is considered to be an official privilege. Federal paychecks are issued from the District of Columbia, giving federal employees compensation effectively connected to a federal area under exclusive United States jurisdiction. Thus, federal employees are liable for income taxes. Social Security payments are considered taxable income because they are from an official privilege and are issued from the District of Columbia. Chapter 4. Congress creates a second United States with its own citizens and its own laws. And this is where I wanted to get to in this book. And this is really, really important, but I needed to read into it so you understood the context of where we're going. As our founding fathers predicted, Congress did not like the restrictions the Constitution and the Supreme Court placed upon them, but they had to suffer through it for over 70 years. Then the freeing of the slaves and the exhaustion of people along the highly divided opinions on several issues now gave Congress the opportunity it had been waiting for and grabbed it. All right, now you have to understand why Abraham Lincoln freed the slaves. It was in the Treaty of Trent. And when they had to reorganize and they had to reconstitute the debt, ladies and gentlemen, in order to move that debt over so he wouldn't fall in international commercial dishonor, he had to abide by the Treaty of Trent. Treaties are extremely powerful, okay? And so by doing that, what he did is he didn't actually free the slaves, he enslaved everybody in doing so, because then they started to pledge everybody's biological property, assets and real estate towards the bankruptcy. so they could reconstitute the debt, which the definition of a constitutor means to roll the debt over. That's the very definition of a constitutor. That's what they do. They take debt from one entity and they roll it over to another. Remember, the Constitution is nothing more than a banking charter. Like many people at the time, Congress was not willing to give the freed slaves or the Indians the same freedom and rights the whites had. Both the Indians and the slaves, freed slaves, were looked upon much as savages, not having the ability to understand the common law and respect the rights of the whites. Even the Supreme Court upheld this point of view in the Dred Scott case. Now, here's the problem with this. The American history books are so full of shit, it's not even funny, because many of the best authors in the 16th, 15th century were men that were melanated men. Okay, so this whole hypocrisy of everybody was a Neanderthal that wasn't pigmentally challenged is bullshit. It's bullshit. In fact, the first president of the United States was a melanated man. Okay, it wasn't George Washington. Go do some real history and you'll find out there were like 12 or 13 people before George Washington, because that's right. The colonists were here long before 1776. Everything's just one day 1776 happened and ta-da, ole, we're America. No, that's not how it happened. There were a lot of melanated men that were very brilliant. A lot of your legislation was written by melanated men, and they hide that from us here for whatever reason, which is just absolute bullshit. All right, so don't think for a second that melanated men couldn't read and write, because they wrote a lot of things, ladies and gentlemen. Thomas Edison didn't create the fucking functional light bulb, all right? It was a melanated man that figured that out. Thus, Congress established a new inferior citizenship for freed slaves and Indians through a new constitutional amendment known as the 14th Amendment. The amendment read in Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. In reference to the 14th Amendment, the Supreme Court stated, the persons declared to be citizens are all persons born or naturalized in the United States. Now, the United States is a 10 square mile area, ladies and gentlemen. All right, that's what the United States is. It's identified as Washington, D.C., District of Columbia. All right, that's the United States. The evident meaning of these last words, okay, not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. Elk versus Wilkins, 112 U.S. 94-104. Black's Law Dictionary, 6th edition, defines subject to as follows. Subject to, liable, subordinate, subservient, inferior. Okay? Now pay attention. From the beginning, Congress stretched the interpretation of the 14th Amendment far beyond anything actually thought to be in the amendment. For instance, Congress interpreted the subject of the jurisdiction of, in the new amendment, to apply to the states as well as to all areas of the federal government. In this manner, Congress set up a federal agency in each state with a shared jurisdiction with the state. Okay? Nebraska is different than state of Nebraska. One's a federal municipality, umbrella corporation, or subsidiary corporation of a major umbrella corporation, right? They set up the territorial agencies within the states as well as within the federal government. This gave the new federal agency extensive power over the people. Not over the people, over the people who willfully and ignorantly volunteered to participate in their Ponzi scheme, okay? The states went along with this when the federal government split their territorial taxes with the state. Before the 14th Amendment, the Supreme Court had long denied this to Congress. This resulted in what is known as the territorial United States. So now, there are two United States, each with its own citizens and its own laws. There is the United States of America, which if you're intelligent and you're listening to what the hell I'm telling you and processing it, you'll be able to decide for yourself where you fit in, all right? With the 50 sovereign states of the Union under the Constitution, and there is the territorial United States with the 50 state territories under Congress and the federal state agencies. Now the question becomes, which one are you a part of? So, what determined if a person was under the jurisdiction of the 14th Amendment? Was their citizenship established through their state republic under the Constitution, as it always had been? Two questions arise. First, is he or she residing, or is he or she domiciled? If they were residing, their citizenship was in the 14th Amendment. If they were domiciled, their citizenship was under the basic, organic, original Constitution. Second, if he or she is subject to the jurisdiction thereof, if he or she is under the general jurisdiction of the government, he or she is a 14th Amendment citizen. Neither of these two deciding factors involve race. They depend on decisions of the individual. Are you paying attention? The new amendment gave no rights as the original Constitution did. The new amendment gave no rights as the original Constitution did, only privileges and immunities. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Under the 14th Amendment, a citizen has no rights whatsoever, only privileges and immunities. Go to the federal court where a 14th Amendment issue is being tried. The judge will say, "You're privileged to," as opposed to "your right to." This is plainly stated in the federal law cases. U.S. citizens owe the income tax for the privilege of living and working in the United States. A right is unalienable. A privilege can be taken away at any time. Under the Constitution, everyone has an absolute right to life and cannot be taxed an income tax except for privileges she must apply for. So, how did Congress get the Supreme Court to allow it? It would be clearly unconstitutional except for one thing. The 14th Amendment jurisdiction is only in the territorial United States. The 14th Amendment has no jurisdiction authority within the 50 Union states. How then could Congress have convinced the people to claim their citizenship outside the 50 states? All right, the 50 Union states. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in the Constitution will be so construed as to prejudice any claims of the United States or of any particular state. United States Constitution, Article 4, Section 3, Clause 2. Constitutional restrictions and limitations were not applicable to the areas of land, enclaves, territories, and possessions over which Congress had exclusive authority. Downs versus Bidwell, 182 U.S. 244. In exercising its constitutional power to make all needful regulations respecting territory belonging to the United States, Congress, under Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution, is not subject to the same constitutional limitations as when it is legislating for the United States. Hooven versus Yvette, 324 U.S. 674. The jurisdiction of the 14th Amendment was and is over the military installation, the seat of the federal government, Washington, D.C., the federal area not yet admitted into statehood, national forests, and later the federal possessions gained from war. Do you live in any of these? Did you earn any money in any of them? There was nothing in the new amendment to separate race, and anyone could claim the new citizenship. This means that by the 14th Amendment, citizenship, one was surrendering one's constitutional rights unless one could claim both citizenships, which few people know how to do. These constitutional rights were well known at the time to be the people's most valued possessions, as the Supreme Court has stated repeatedly. Among those unalienable rights, as proclaimed in the Declaration of Independence, is the right of men to pursue their happiness, by which is meant the right to pursue any lawful business or vocation, in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties, so as to give them their highest enjoyment. It has been well said that the property which every man has in his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. To hinder his employing in what manner he thinks proper, without injury to his neighbor, is a plain violation of the most sacred property. Butcher Union Co. versus Crescent City Co. 111 U.S. 746 at 756 through 757. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona 384 U.S. 436 at 491. No sane white person would have knowingly claimed the 14th Amendment citizenship. And yet, if you ask almost any American what their citizenship is today, they will tell you, I am a U.S. citizen. In so doing, they are claiming their 14th Amendment citizenship and admitting they are subject to the general jurisdiction of the federal government and have no constitutional rights, only privileges and immunities. As a result, Congress established many new agencies clearly unconstitutional except in the territories of the U.S., and the people are claiming to be under that jurisdiction. And now the U.S. citizen is far, far worse off than the colonists could possibly have imagined. How did Congress get the people to claim this territorial citizenship? Are the people that pleased with the way Congress rules them? No. We have become a nation of people fearing the government, especially the IRS, and most people are even afraid to complain. How did Congress convince the people to accept the 14th Amendment citizenship and give up their constitutional rights? Trickery and deceit. Very rarely is anyone told that the income tax laws apply only to privileges or only in the territories. But they have used one other method of enslaving us. They continually find samples of people that haven't paid their taxes, who do not understand what the law is, and convict them. These people usually think they have constitutional rights and have no idea they have lost them, much less how. If they can convict and throw a few of them in prison and make enough publicity from them, the common people soon begin to live in terror of the IRS. Furthermore, they set up the free public schools and threatened the parents with taking the children away from those who did not put their children in a new free school. Then they raised the children in 14th Amendment law until the people no longer knew there was anything else. Thus, America is no longer the land of the free and the home of the brave, but you can very easily change that if your personal life in your personal life and claim your constitutional rights. We can, one by one, reclaim our nation of, by, and for the people, and all of this is easier than filing that tax form. Almost all the tax laws are under the 14th Amendment. If you are a basic constitutional citizen, you are not subject to the vast majority of new tax laws. The Supreme Court is still on our side, and the IRS and other 14th Amendment agencies live in fear of it. Thanks for joining me. We'll come back later with Chapter 5. There's only like 15 more pages left of this book. It's absolutely fantastic. I have so much respect and love for you, brother. I appreciate you, man. It's good to see you this morning. You guys be safe out there. When we come back, Chapter 5 says it doesn't say that. Congress wants our money and jurisdiction over us and always has. Now, you got to understand how the Congress, the legislative, the judiciary branch, they're all under the executive branch. They're all working for the Queen of England, all right? Don't believe me? Go ask any CPA how many tax classes there are, all right? Now, Mr. Anonymous pointed this out to me. He goes, Derek, I talk to a lot of people that are privy to information, right? And I go, He goes, just ask any CPA how many tax classes they are, and they'll never be able to tell you. Well, how many are there? There are 9. I said, really? He goes, but you'll only hear about class 2 and class 5 unless you're really intricate in business. If you're really good at business and understanding and navigating these waters, you'll know all 9 of them because you'll use them at some point, for your benefit, of course. Anyway, with that being said, the class 5 is a gift and estate tax. It's your 1040. It's a tribute to England. And many of you people don't realize that by doing that, that's exactly what you're doing. And there's supposed to be, your employer is supposed to have a notice published somewhere in the building. It doesn't have to be in the break room. There's no specificity of where it's supposed to be posted. But before you fill out your W-4 form, it's supposed to be posted. And the notice says this: if the employee desires, not is required, desires to fill out a W-4, then the employee or the employer must provide it. Don't shoot the messenger. But you didn't get full disclosure. You start filling out forms thinking that it was the way that it had to be because, like my pops used to tell me, Derek, you gotta eat, breathe, shit, shower, sleep, pay your taxes, and die. I mean, that was literally the mindset of the community that I was in. It's just that way because it's that way. It's always been that way. Nobody questioned it. Nobody asked anything about it. That just didn't sit well with me when everybody's running around going, Derek, you're free. You should be so happy. You're so fortunate to be born in the good old USA. And I just walking around like, why are these people stealing from me? At 13 years old, I had a full-time job. People were not stealing from me then because I was being paid under the table. And that was nice. And then I got a little bit older and I got a different form of occupation. All of a sudden, they're taking Medicare, FICA, Social Security, and I'm going, wait a minute, you thieving, rotten bastards. Why are you taking my shit? I worked for that. Where you get off taking my shit? It was only as I grew older that I realized taxation was nothing more than theft. And I only came to realize that because when I was a young lad, I didn't ever pay no taxes, all right? And the world was still good. And the taxes that I did pay were on the things that I acquired, okay? And that is understandable to me. Like, for example, when you're buying fuel and you're paying a road tax, I get that. Although our roads are absolutely crummy and people really need to get on top of that. I can understand having a tax on purchasing things. What I don't understand is having an income tax, a purchase tax, a sales tax, and an annual tax every year for the things that you should already own outright. All right. So anyway, when we come back, chapter 5, it does not say that. We're going to get into Congress and stuff, but I got to charge up my phone. I got to charge up my computer. Again, we got class. Class will be a lot different than this. I'm just reading to you guys now. Class will be so much different with what you can do as far as the land patent. And Jackie Figg recently passed, bless her soul, and one of her constituents got a hold of me and said, before Jackie passed, one of the things that she wanted was a teacup of land. And I understand that sentiment. I get it. I understand exactly what she was chasing because she had finally came to the realization of how important that land patent is and calling it forward in your good name. And all she wanted was a teacup, because that's all it takes. A teacup that goes from the core of the earth out into the stratosphere of the universe. All right? And that's all it takes to secure your rights. And because your rights are directly tied to the land. They're directly tied to land, not real estate and property. Real estate and property is part of their federal territories, municipalities and stuff. As soon as you can wrap your mind around the overlay that they have in their fictional realm, the better off you'll be. So thanks for joining me, and I'll see you later on this afternoon.